The statement to law enforcement, we actually had three speakers, Mr. Maples, Mr. McIver, and the gentleman that I've never met, another lawyer. Mr. Leipold. And there were concerns about, and I'm remembering that it was Mr. Maples who did most of the talking, lawyer talking. Were there issues with anything Mr. McIver said? If we're segmenting it out, and if the state were to be limited just to what he said, could they press play, it runs, and we're done?
That's right. The transcript is 86 pages. The first 26, Mr. McIver's not even in the room. Of course, it's not even adopted by acquiescence. Then you have 31 pages where he's doing all the talking, maybe the lawyer saying a word or two. And then you have another 30 pages where he's out of the room again. So what we're focusing on in this motion is the first 26 pages of the transcript, the last 30 pages of the transcript, but he's not even in the room.
Okay.
But there are, as I understand it, there are
Okay. Who's going to argue that for Mr. Rader?
Yes, sir. I'm available to argue that.
Okay. Well, I just want to get oriented first. So the state, if it had its way, we want to play the entire thing, lawyer part, McIver part, and lawyer part?
If we had our way, absolutely.
Okay. I just started poking around with the agency last night, knowing we would be talking about this a little bit. And certainly there are exceptions. It's an admission through agent. But Mr. Samuel, unsurprisingly, is way ahead of me on this. Well, adoption by all these different things. That how would he know if he hadn't even come in the room yet? Is there a nutshell you want to give me, or cases that I should look at, or you want to give a full-throated presentation? I have not watched the interview, so I'm not going to be able to nod knowingly when you say, well, 10 minutes in, when he starts talking about this, my client told me I could tell you this. That might be a stronger part of it for you. But it'd be helpful for me to hear why you think what Mr. Maples or Mr. Leipold had to say to law enforcement ought to come in.
All right, just for ease of movement, I'll be right here.
Wherever you'd like to be, as long as Ms. Harris and the defense can hear you, we're good.
Okay. The gist, Your Honor, is that this was a prearranged meeting that had actually been brokered by, correct me if I'm wrong, anybody, but by the attorneys for the defendant, specifically Mr. Maples.
So there's some, I assume it's an Atlanta police person who could come in and say, we got a call from Mr. Maples saying a client wants to come in and talk with you.
Well, there's certainly somebody from APD who could go through the entire process. I believe originally it was contacting the defendant directly. He said he'd come in on a certain day. Then Mr. Maples became involved with representation. He said, wait, let's wait another day. And then Mr. Maples made sure that the defendant came at the pre-appointed time.
So the police reached out to Mr. McIver. Hey, we'd like to talk to you about what the situation was. Hey.
Yes, they reached out to Mr. McIver. They were still in the fact-gathering stage. Mm-hmm. And this is actually reflected by the fact that the first thing, well, not the very first thing, but the first point that Mr. Maples makes as he's entering is saying, this is an open and shut case. Speaking to the detectives, saying this is not a murder. This is what they look like is open and shut. Easy peasy. And they begin to go over the evidence themselves.
They, meaning Mr. Maples and whoever, the detectives who were there.
The conversation in the first 26 or 26 pages is Mr. Maples and Mr. Leipold, who I believe are incorrectly identified in the transcript. And then the two detectives for APD, Detective Smith and Detective Zimmer. Who I believe are correctly identified. All this to say, they come in, and I believe the defendant comes in and introduces himself before leaving the room in the first couple of pages, or the first couple of moments. And then the conversation is between the detectives and Mr. Maples for the most part.
Okay.
And there are statements beginning at page 6 from Mr. Maples to the effect of, here's what Mr. McIver's going to say. And again, at page 10, much the same, exactly. I can give you the story he's going to tell you. It's pretty much what Dan and Jeff told you. And he said he did this, and then he's relating, in fact, actually physically pantomimes what he was told by the defendant.
Okay, I assume that's all in there. I'm not, Mr. Samuel isn't going to argue that what's in the transcript is not in the transcript.
Okay.
What's the legal framework that we lay on top of that to say Maple said all those things, so he is in fact Mr. McIver's agent, and it comes in as an admission of Mr. McIver versus whatever I'm going to hear from Mr. Samuel in a little bit. Like, it's not that easy.
Yeah. Yes, Your Honor, this is a rarely litigated issue, so we have to look to...
First for me.
Exactly. So we have to look to the federal circuits. And in fact, there was a case just recently, which I can provide, I believe I only have one extra copy.
I just need a citation.
It's State v. Wood. It's a Court of Appeals case that's up on cert right now, awaiting a decision from the Supreme Court on a separate issue. The citation is 338 Georgia Appeals 181. That case is grappling more with in judicio admissions, so I believe it was a stipulation or something to that effect. And they get into the rule, the various flavors of it in that decision. There's a footnote in the Wood decision, footnote 4, where the court says, we sort of, it's a standing fact of Georgia law that anything said by a defense attorney in the presence of a defendant is adopted as a statement of the defendant.
Okay.
The question is, when we get just outside of that, what do we do? And,
When you say just outside of it, our scenario, apparently Mr. McIver was around. If he did come at the very beginning, here I am, hi, then he leaves the room. He's not physically present, but he's nearby.
he has come with the absolute expectation, and not a mystery, that his attorneys are there to speak to detectives. He's going to come in and make a statement, and then, well, it turns out that his attorneys make more statements. But it's not a mystery to Mr. McIver what's happening. And I don't think there can be any serious allegation that whatever conversation is taking place wasn't his lesson. But the Court of Appeals in Wood says that we note that under the current, the new Georgia statute, a party may use a statement by the opponent party's agent as an admission by the opponent, and federal case law, which is held
You're going to have to slow down on that and get it.
I apologize. A party may use the statement by the opponent party's agent as an admission by the opponent, and federal case law, which is now relevant, has held that the federal counterpart to this statute allows statements by an attorney to be admissible against a defendant in criminal cases. It then the theory that the court looks at in a lot of detail in Harris is essentially to say there's a lot of reasons to be careful when looking at whether to admit these kinds of statements as statements by agents, particularly in a criminal case. But in this situation, where a defendant's attorney is testing out a defense theory and simply presenting a version of the facts which can later be contradicted, that is not protected under any sort of concern. It's not protected by any constitutional right. It is simply inconvenient. And where it is clear that what the defendant's attorney was doing was testing out a version of the facts or a theory of the defense with a third party, those statements can be held to be the statements of the defendant and can be admitted.
Has your research shown anything about what test, if there's a test, is to be applied to a particular interaction between attorney, and here it's the police, but the witness, as to whether that was authorized or is sort of an agency relationship? It sounds like you'd be able to show that Mr. Maples or Mr. Leipold or both represented to the Atlanta police were the lawyers for Mr. McIver. And that would establish some connection. But I'm just wondering what the case law says, if anything, about what you need to show about what Mr. McIver said to agree with his attorneys. Now, you go in, you soften them up, you talk to them first, then I'll come in and talk. I authorize you to, presumably it's not so stringent that here's the contract. I authorize you to say these things to the police as my agent. Anything outside the four corners of this, that was not you serving as my agent. But it's probably a little bit more than, well, yeah, he was my lawyer.
The cases that I've looked at do not provide us with a handy, here's a checklist, 1, 2, 3 test. What they do tend to do is look at the concerns that the courts are trying to avoid with the implementation of this rule in criminal cases. They say, are the defendant's rights being violated in any particular way in these instances? Most of the cases seem to take for granted that the statements which are presented are certainly being presented in the context of the relationship between the defendant and his attorney.
Why else would he be talking to the police?
When the defendant's attorney says, here's what he's going to tell you, this is what he says happened, this is his version, and he's actually physically reenacting what he's been told, and it's all in the context of the very first thing, as I told you earlier, that Mr. Maples said, which is that, guys, this isn't murder. There's no reason to go any farther on this.
Is there anything different in your mind about the other piece of bread in the sandwich where Mr. McIver leaves and then again it's the attorneys talking with the detectives? Was there anything Mr. McIver said before he left? All right, that's enough. We don't need to talk to them anymore? Or what's the point of the...
There's actually a statement, Your Honor, as Mr. McIver is leaving. I'm not going fishing right now. It's in the transcript where his attorneys say, Tex, step outside. We're going to continue talking with the detectives. And he does.
And do they talk about something all that different from what they talked about in the first 26 pages?
There's not as many specific facts as discussed in the first 26 pages, but it is their representations to the detectives about the version of facts that they are urging on behalf of the defendant. That was indeed the purpose of the entire meeting, Your Honor, was to put forward a version of facts that would indicate to the APD that this was not a murder investigation.
So I just want to make sure I'm following this because it feels like you've flipped it around. I thought the purpose of the meeting called by APD was to gather facts in furtherance of their investigation. The two attorneys agreed to let their client talk with the police, but they prefaced their client's conversation with 26 pages of their own words, relaying what they say their client's going to say, and then they concluded the interaction, I guess, by reiterating some of that and talking some more. But as I'm understanding it, and that may be why Mr. Rucker had you in the grid there, it was a police-initiated conversation, not Mr. Maples and Mr. Leithold saying, we need to get out there with our story, and so let's reach out to the police and get on in there.
I didn't mean to indicate I was flip-flopping, Your Honor. I meant to say that the meeting was initially, I believe, requested by the detectives from the APD for Mr. McIver to come in and provide me with facts.
Okay.
There was a certain date agreed upon, and then that date was delayed at the request of Mr. McIver and his defense team. And then I believe the following day they came in. So certainly it was initially called by APD as a fact-finding mission, but there was also a clear goal, a clear intent on the part of Mr. McIver and his attorneys to indicate to the detectives that this is not a murder investigation. It's stated from the very outset. I also want to correct one thing that Mr. Rucker provided me with some facts I've forgotten. The second half of the conversation, after Mr. McIver had left the room, there is a discussion about possible motive and the discussion about the financial straits the defendant may or may not be in, and an indication by his attorneys that there was no financial motive.
Okay.
So in each case, there are representations being made by the defendants that are, in the words of the Harris Court, testing defenses. There's another case I want to put before Your Honor, the United States v. Ahmed, which actually is 2006, U.S. District, Lexus 53943.
Do you have a non-Lexus say?
I don't believe I do. I have a copy. I have right to your
Yeah, this one I will take as a copy.
The United States v. Ahmed, Your Honor, looks at the facts of the Harris case and also other cases trying to evaluate whether...
There is a Westlaw site.
I apologize.
2006, Westlaw 321-0037.
And, Your Honor, that one actually looks at a situation where a defendant's attorney created a table and then provided it to the prosecutors before any plea negotiations were taking place. The information contained in whatever factual table was created or later introduced at trial, and the court found that that was fine as an admission through the agent of the defendant, his attorneys. That case is useful for, again, looking at the sort of framework that the courts provide us, which is what concerns do we have about admitting these types of evidence, and is there cause for concern in this factual scenario? And what they find is that, similar to the Harris court, none of the, whether the defendant's effective representation at trial was diminished because of this. Whether the cool relationships between attorneys and their clients, and whether there are any Fifth or Sixth Amendment problems arising from this testimony. What they find in that case is that this was during informal discussions. A meeting was set up where the defendant, through his counsel, elected to make a formal presentation of facts, which had been gathered specifically by the defense for the purpose.
Don't go too fast.
I apologize.
That's okay.
Essentially, that they had gathered facts for the specific purpose of providing them to the government. And that is similar to what we have here, where it was called by by the detectives, and they come in prepared with statements. They say, this is what he's going to tell you. This is what happened. This is our version of the facts. That is strikingly similar to what took place in Ahmed. And the kind of meeting that takes place in Ahmed, so there's no legitimate claim that you can expect that such discussions would be privileged in the absence of the an expressive agreement to that effect. Essentially, when you come prepared with a version of facts, argument, which is what we see from the transcript and the video, then you should not expect that these statements are going to be interpreted as anything except the representations of the defendant as to why he is not guilty.
Okay. Mr. Samuel, I will get up close and personal with the transcript, so I would welcome you to dive into it where you think it's pertinent. But I think you hear what I'm struggling with, which is what hallmarks of agency is one to look for beyond, hey, this is Tex McIver's attorney calling me back. Actually, we'll be there with him. We want to talk to you. And here we are on behalf of our client. I'm trying to ask it clearly, but I'm struggling with, since, of course, I don't know if there's a way the state could ever, they can't call Mr. McIver to say, tell us what you told Mr. Maples he could do and couldn't do. So that can't be the test, is what did the defendant say. How do you work through it?
Well, first of all, Mr. Maples is here today. My understanding is we were going to hear a lot of testimony from Mr. Maples.
Okay.
And I told Mr. Rucker last night, why don't we see if we can narrow the issues here, but we managed not to do that.
You can help.
We can always take this up, see if we can work it out in the next couple of days, but, there's nothing terribly dramatic about what is being said by Mr. Maples in these portions. But what he does say is, let me tell you what Danny Joe told me. So we don't even have a problem of what or the benefit of he's simply repeating what the client said. And it seems to me that the prosecution is moving away from the hearsay problem and just saying no matter what he said, it comes in. He could say, the sun rose in the west today because I dreamed about it last night, and Mr. Maples' statement would come in because he's the lawyer for the defendant.
I didn't realize there was a hearsay concern. We had touched on this only briefly, and I had seized on, at least remembered, the agency concern. So that's why I did my homework. I agree with you.
That's why it's an 801. It's all an 801 problem, but why are we allowing one witness to say, in essence, what is being held against Mr. McIver? It's the 801 B2, C, and D.
Okay, fair point, but agency would be the exception there, or maybe not hearsay, whatever. I hadn't realized that part of what Maples or Leipold was saying, well, let me tell you what some other people said. That is different. I'm not suggesting that Mr. Winkler was trying to gloss over that. We hadn't dived that deep. That ought not to be played. Mr. Maples saying, and here's what other people have told me. And I'm trying to work through when he is simply saying, this is not a murder case, here's how it happened, and this and that. Why is that not an 801D2 situation?
Because he has to be acting within the scope of his authority and saying things that he's authorized to say.
And how does the state ever show that?
I'm prepared to put Maples up there. But they subpoenaed Mr. Maples to come here today. And I expect him to say that some of what I told him was things I learned about 20 years ago when I represented him in another case, and I was just reiterating that stuff. And no applicability to today's events. In fact, it's just flat out inaccurate. Everybody agrees the facts are wrong that he recites about his income, about his resources. And Mr. Maples will say, he didn't tell me anything about those things in the last 15 years. He will say that some of what he will say is because he interviewed Danny Joe Carter. And he came in to make a presentation to the prosecution just like any lawyer would do. We all do it. I did it with you when you were prosecuting. Let me sit down, tell you my best case scenario. I don't think anybody ever would expect the first witness for the government in that case would be Mr. Samuel's recitation, even if there weren't a proper agreement. So, we have that problem. So, maybe I should be citing 403 also. What is the relevance of this? If we're going to end up having to call Mr. Maples, and Mr. Maples then says, I'm doing lawyer advocacy. I wasn't trying to make representations of fact. I was testing the waters. I was doing the same thing the police do when they do interrogation. I was learning things on the fly from this interrogation from the police as much as imparting information. I learned things from the doctors at Emory. I was regurgitating some of that. Again, Danny Joe Carter, kind of the biggest one. And some of it, I was just testing the waters to see how things would go. So it's all a hearsay process, in my view. Although not what the prosecution say now, it doesn't matter. They're not even offering for the truth of the matter. So we're just offering it because some lawyer came in and told us things that are lies. And we think you should consider that in evaluating whether Mr. McIver is guilty or not. And if that's the case, then I think my argument has to shift considerably to 403. What is the relevance of the fact that Mr. Maples came in and he spun? What's the relevance of that?
Okay, I mean, it's what you'd expect an attorney to do on behalf of a client, and I'm not saying that makes it relevant. I'm agreeing with you.
Best case. This is how I want you to view this case. There's things about his knowledge of guns and things like that. They make fun. Oh, he's in the Air Force. He's not in the Army. And what would he know about guns? People in the Air Force don't learn anything about guns. And then they're all making jokes with each other, the police. And there's so much garbage in here. Well, I'm not holding it against you. You were in the Army, not in the Air Force. The police are talking to him about that. The police are making statements. Do we get to use that? Do we get to use that? The statute actually excludes it, but it's going to come into evidence. The police say, oh, yeah, this is clearly an accident. Or words to that effect. Don't we use that in closing argument? The police agreed it was an accident.
I mean, if the statement's in, you'd be able to talk about what's in the statement.
Let's see when the state starts for that.
So, what are your thoughts about what I just heard from Mr. Samuel? I didn't realize, and don't necessarily know Mr. Maples' sources of information, but if he is relaying to, well, I'm just trying to work through it. If the defendant had said to the police, oh, I'm fine financially, I've got all sorts of money, and that's not accurate, that doesn't not come in because it's not accurate. That's his admission. But here we have inserted an agent, and if the agent's testimony, not in front of the jury, would be, it's not what my client told me, at least not this time. It was a different case long ago, and I was just parroting some of that back. How do you work through that?
Well, there's two statements I want to draw your attention to, lest it be the court's understanding. And I know you're going to read, but I'm not going to read this entire thing to you.
Good.
There's two statements that are important. At page 6, Mr. Maples says, and I can give you the story he's going to tell you. It's pretty much just like Danny Joe told you, but he doesn't know the details she knows. And then he goes into a relation of the events that are clearly, with that context, coming directly from the only other person who can know it.
So
One other.
I'll let you do that other one, but what this is telling me, and it was helpful to have Mr. Samuel flag some of the things he did, this doesn't sound like either the beginning of the interview, just lawyers, or the end of the interview, just lawyers, is a press play and step back. It sounds like you ought to focus in on, no, this is the 30-second segment that we think is not what the doctors told Mr. Maples. It's not, and it could be because it's preceded with something like that. And then if we need to ask Mr. Maples, we can ask him, well, what was your source material for that? My client, I talked to him about it. And of course I was going there. He wanted me to talk to the police about that. That's why he brought me on board. But if there are, making the numbers up, 3 minutes worth of Maples dialogue where he's referencing financial data that are 2 decades old, then that doesn't come in the same way. You'd have to come up with a different theory than agency. It seems to me, I don't, like I said, I'll read all this, but it's sounding to me like the state ought to, with a bit more precision, look through the first 26 pages and the last 30 to say, we want to play these excerpts. And then there would be a discussion with the defense as to, do you still have that objection? Do we need to prove it up by getting Mr. Maples in here as to those segments? Possible completeness issues, but if they want to play more, they can play more. So what's your thought about that?
I hear what Your Honor is saying, and part of the Ahmed case speaks to that to an extent. It's that when the purpose of the meeting is to present a version of the facts, it gets less into, the facts there are very specific in the Ahmed case. And there's not an examination of, okay, well, where did they pull these facts from, an SEC filing or some esoteric and detailed source? It is, what was the representation made by the defense team when they were sitting down with the state without any understanding that this is privileged or unusable or anything like that? There is a statement from the Harris case that says effective advocacy requires strategic and tactical decisions at all levels of the criminal process. The fact that a lawyer's unsuccessful maneuver might be used against his client will not unduly chill legitimate advocacy. And that's essentially what they're saying is you gotta, at each step of the process, each side has to decide how they're going to present themselves to the other. What we have here is the defendant, through his attorneys, providing an array of assertions that are basically pleading his case before they're even in. One of the things you'll see, just for completeness, I mentioned 2 things. I'm going to get to the second thing.
Sure.
At the very bottom of page 10, Your Honor, you see Mr. Maples say, after there's a discussion of relaying of investigative foundation, and he says, and so he's going to tell you, meaning the defendant, and then goes into a very specific recollection of where exactly the gun was, where the bag was, how the gun was pointed, facts that can only come from the defendant. So I hear what you're saying, that there may be specific points that the state could focus on, but I believe that the statements or the consideration of these facts, this scenario in Harris and Ahmed and Mike cases indicates that when the purpose of the meeting is to come in and plead a certain case by the defendant, then the statements of his attorneys are considered those.
Okay. Here's my proposal. I will read through the transcript, and for that first phase, when it's lawyers and detectives only, and that third phase, when it is once again lawyers and detectives only, I will flag the areas where it seems like the 801 D2 argument is compelling to give you an opportunity to say, this is why I don't think it works there. By not flagging an area, that would mean I think that Mr. Samuel has a good point, whether it's hearsay, meaning it's just Maples, it would be Maples talking, it's an out-of-court statement that doesn't have an exception for the truth of the matter asserted, or it's hearsay in a different way. Danny Joe told me that's not Mr. McIver told me, it's Ms. Carter told me. And so it may be that phase 1 and phase 3, or parts 1 and parts 3, have to be broken apart a little bit. It doesn't sound like it's quite as clean as I had hoped it would be for thinking about it. So I'll do that with parts 1 and 3. Is there anything about part 2 that you have a concern about? If in the end the ruling was you can play part 2, it doesn't sound like it's a voluntariness issue or anything. Just 2 lawyers sitting with him.
Right.
Okay.
The only thing I'd ask is, Mr. Rucker and I did talk about trying to work this out. We just didn't have time this morning. Is if it's not coming in an open statement, and clearly not coming in the first week as the detectives are on the list, we still may need to have an evidentiary hearing with Mr. Naples. Because if he gets to understand that the person not in the room and says, I didn't have authority to say any of this, I was just spinning. I think in a 403, you have the right to say, this is just pointless. This isn't helping you with anything.
Well, if you didn't have authority, then I don't even think it's 403. They would become hearsay. It's not Mr. McIver's statement. But I'll tell you, I draw a cue from the preface. Here's what he's going to tell you. That's the kind of thing that I will likely flag as, tell me what the issue is here. And we may well need to have Mr. Maples talk about that. I'm not saying there wouldn't need to be a hearing. I also like the sound that you guys continue to talk about it, because it may be that you're willing to throw in the towel as to this, and this because of basically how he said it, or because of things you and Mr. Maples talked about. We don't need to have a hearing if we don't need to have a hearing.
Right. And a lot of it is, Mr. McGowan's going to tell you X, Y, Z. 5 minutes later, Mr. McGowan comes in the room and says X, Y, Z. Why are we fighting over this? But there's other things he says that Mr. McGowan never says, and clearly there's not something that he even talked about, because it's not even relevant to the facts of this case.
So I'll read through it, and I'll let you all know the areas that strike me as being subject to that 801 D2 agency situation. And that way the state can push back if they think I haven't included some things that ought to be in there. And Mr. Samuel, you know the areas that I think maybe ought to come in under that rubric. But I agree that we still may need to hear from Mr. Maples. Mr. Rucker, is the state's opening going to, I assume it wasn't going to include playing anything that Mr. Maples or Mr. Lightbulb said?
No.
Okay. All right. More work for me. Let's talk about the tank team situation. Mr. Rucker said there were 5 items, and we don't.
And I misspoke, Judge. I apologize.
Big surprise.
I apologize. It doesn't happen very often. But
Only when you're speaking.
I had been going back and forth with Mr. Samuel about this issue. So I had read his email where he said, "Listen, it's just way too many documents." My immediate response to the person who was kind of handling that for me was to say, "Hey, pick 5 things,
Okay.
and send it to Mr. Samuel, and let's just work through 5 things." Okay. Apparently, I think a few more things were said that I didn't know about, so I do apologize to Mr. Samuel about that. But my intent was not to overburden him with lots of documents, but to pick things that I felt like were not on the privileged list, were not privileged, as flagged by the tank team, and could easily be looked at pretty quickly and say, yay, nay, or whatever, so we can get those documents immediately.
If it hasn't been flagged as privileged, you may all have sorted out your own protocol. If it hasn't been flagged as privileged, why are you needing to get Mr. Samuel's blessing to begin
Because
with?
I thought that's what the court kind of set in place for us when we had our telephone conference.
Yes.
Oh, because that way, because the defense has said we don't have the time nor the interest in wading through 50 gigabytes of data, and so the state can simply say, here are the things we're interested in. But I'm just not remembering then what your veto authority would be if it's not privileged. If it's available on both sides.
Right. The protocol that we've set out has been in place since day one was that Anita Thomas would send me the log, and then we get to look at the documents to make sure she did it accurately.
Okay.
So, and we did that back in your chambers, 2 months ago. We went through, we agreed with every one of her assessments and turned it all over. Then we had this, the situation 3 weeks ago that led to a conference call with the court, where there were, 7,000 documents. I said, I can't really clear any of this. So I said to Mr. Abadi, give me 25 things you really want, or more than that, actually. And we did it on the phone in 20 minutes. I said, you got it all. I think there were a couple things I disagreed with. He said, don't worry about it. Everything went through. Well, then the computer stuff started coming back. And that started last week.
Okay.
During jury selection, we're suddenly told we have 50,000 documents, 75,000 documents. I said, I'm not doing this anymore. There's no excuse why this took this long. I don't care whose fault it is, the GBI, the state for not pushing them, the court, the tank team.
It's not the court's fault.
No, anybody except the court. So I just said, I'm not going to do that. So I think Mr. Rourke made a good decision. Give him 5 things. So they gave me 27. I said, no problem. I'll go through those. Item number 1, email with counsel. Or item number 2, email to counsel. Item number 3, email from McIver to his attorney. I'm like, what, are you kidding me? This is the non-privileged stuff? I said, to begin with, I got to see what these documents are that say right on the document, it's an email between Claude McIver and his lawyer. And you're telling me not privileged? Now, maybe they're talking about, can we meet at the Braves game tonight? Well, maybe so. Maybe it's not privileged then. But I'm not turning over any of this stuff. And then, point number 2, none, I shouldn't think of it. Out of the 27, I'd say 22 have nothing to do with financial documents. The search warrant you authorized was financial documents. You, in fact, even scribbled some stuff and put your initials and said that's all you contain. It's very complicated with computers. I get that. We have the advantage of a tank team that said some of these documents have zero to do with finances. If it was just a regular old search and seizure of a computer, they get to use the plain view exception. But the plain view exception here is email between Tex McIver and J.D. Calhoun about a meeting with the DA. It has nothing to do with finances. Why do they get to look at that? We're just going to have a suppression hearing. We're going to have a suppression hearing because it's been unlawful. The scope of the seizure, granted, you can take the computer, but once you realize the computer doesn't have financial information on it, or there's certain files that aren't financial information, hands off.
Right.
Unless it's plain view. Well, so with Dickerson, I mean, that gets really complicated because of the timing, right? But first of all, we just got a thumb drive at 11:45 this morning of the actual document. Our farmers looked at some of it. Some of it looks like it's complete garbage and not worth anybody's time because they're probably curious as heck. I want to see an email between Tex McIver and J.D. Calhoun. I bet they do, but they don't have a search warrant. They're authorizing that. Mm-hmm. So what I told them, and I told them last week as well, if you start insisting that I have to produce, that I have to pre-clear, whatever the word is, documents that are clearly not financial records, and you want to get those in your hands, which you can, because they're not privileged, we're going to have a motion to suppress on the unlawful scope of seizure.
Okay. So who wants to talk about that from the state?
If you could maybe just put a pin, I am trying to get Mr. Sprinkle in here, who's the one who actually communicated that to Mr. Samuel.
Okay.
So that I could first ask him a question, and perhaps
We'll come back to it. We've got time. I recall the affidavit and the warrant and the limitations placed on it. So there may be some fascinating things out there, but if they don't relate to the finances of either of the McIvers, then that's outside the scope of the warrant. And that doesn't mean that an email that says Tex McIver to J.D. Calhoun has nothing to do with finance, but email between defendant and lawyer, well, a different issue there. So we'll work through that, but the state needs to keep in mind the limitation that was appropriately placed on the scope of the search. So Mr. Sprinkle gets here, let me know, and we can bend back to that. Ms. Harris, you good? You need a break?
I will go to Judge.
Okay. We'll go a little bit longer and we'll take a break.
Thank you.
8:07. Any developments with that? Any updates? Is this Mr. Sprinkle?
Yes, Your Honor.
Well,
What's your response?
8:07. Why don't you guys talk for a quick second?
Yeah.
Mr. Maples, I suspect you're going to be back.
Thank you for inviting me.
Well, I didn't, but I'm happy to see you.
Kristen, thank you for
All right. don't we talk briefly about 807 in terms of where we are, and then we'll give everyone a break, and we'll come back and talk more thoroughly about it. Were there any witnesses? You all got my email from Sunday morning that went to both sides. Are there witnesses here who will be available for examination, or is the state proceeding by way of proffer, as in an attorney provides the setting as to each of the witnesses?
Right. So when we received your email, we had already taken the step to reach out to the witnesses and to have them come down and be made available for examination if necessary. And so I just have not had a chance to talk to Mr. Samuel to see whether or not there were any that we could handle by proffer. But my understanding is they're all here.
Okay.
So if that's the process we have to go through, then
We might as well get started with it. You would probably want to prioritize them in terms of importance to you, because we may not get through all of them today.
Right.
But why don't we take about a 5-minute break, and when we come back, we'll talk a little bit about the 807 framework, and then you can let me know who you're calling, who you're not. Thanks. Into 11th Circuit. It's a lot newer, but I'm sure it relies on Asatura. And that's Rivers.
Exactly.
Rivers is cited
Exactly.
in all the cases you cited.
Absolutely.
And it has as part of it that the observation by the 11th Circuit that these things that have come in under 807 are considered sufficiently trustworthy, not because it is the Boy Scout troop leader who comes in and swears, I'm loyal, trustworthy, brave, clean, and reverent, but because of the circumstances under which they were originally made.
That's right.
And that's where the state needs to focus.
Right. And then, it's still on the question of indicia of reliability. I would point out that what the case law has said is we're not just going to say, well, that seems trustworthy to me, that seems like a reliable thing to me. It has to be extraordinary circumstances, extraordinary circumstantial guarantees of trustworthiness.
Exceptional is the word but
extraordinary is the word that was used in Rivers. So,
okay.
So it's not just, gosh, why would she lie? Gosh, it seems like a reliable thing. There has to be something extraordinary about it. Because what the cases say, including Rivers, which, as you said, the 11th Circuit spent a lot of time in that case dealing with the whole issue, is we don't get to cross-examine this witness. It's just going to be taken as true. And that's why it's so important that we just make sure it's equal to something where cross-examination would have been pointless. And we will show you, my colleagues will show you through the cross-examination of these witnesses, that cross-examination of her would have been critically important because they didn't even necessarily have an understanding of how truthfulness it was, or the fact that between them they have different understandings of what she was saying.
What if the statement by the declarant isn't necessarily being offered for the truth of the matter asserted?
Well, then,
not that I have a new will, but hey, you know what? Something is in the air. Was that really the new will? This is my new will. Is that really it? Or it's showing that there are changes occurring in estate planning for Ms. McIver.
we have agreed that anything that's not offered for the truth of the matter asserted comes in. We deleted half the 807 notice because we said, look, if the state's not trying to prove that what she said is true, there's no hearsay problem.
So just as an example,
Sure.
Jamie Calhoun presumably is going to come in here and say, Ms. McIver said, I'm leaving you $100,000 and cutting Kathy Johansson out of my will.
Correct.
What if the state says, you know what, we don't really care if that's really what was going in the will. There is some evidence that Ms. McIver is out there changing. Presumably this wasn't said in 2005. That would be a problem because that's before the will we know exists.
Right.
So if Janie Calhoun will say, yeah, I can't give you an exact date, but it was 6 months or so before Ms. McIver passed away. And the state isn't saying, this 100,000, 10,000, is Kathy Johansson being cut out of the will? That's not our point. We're not offering it for the truth of the matter asserted. we're offering it that Ms. McIver was now talking to close friends about making changes in her estate plan.
You know, I'd have to think about that, because first of all, if something like that is being offered not for the truth of the matter asserted, is it being offered for the effect it has on the, what do you call her?
Adherent?
Adherent? Because if Tex McIver doesn't know it, it's irrelevant.
Right.
You got that, 801, 802 problem.
Yep.
What's the point of putting in what people say if it's not for the truth of the matter asserted, if the defendant never hears it? The old problem of the informant, the police saying things. So I don't think that's what the state's arguing here, but if I'm wrong, we'll have to deal with that when it comes up. So I said that the fact that different people are being told different things we think is important. You will also hear that many of these statements, our understanding, were made in 2011, which addresses the point you just made, which is, why is that material to anything? If people in 2011 are being told things and there's no other conversations for the next 5 years, who cares? It may be the most believable thing that's ever been said in the history of the English language, but who cares if in 2011 there were conversations being made? And you will hear again from my colleagues that there was a lot of talk in 2011, and then it stops for the most part. I want you also to focus on some of them are so ambiguous, and I've got one or two examples, but you'll hear them when they come in. Mr. Rickert, for example, the only thing he's going to say is that she said, "I don't know what he's going to do," apparently in the context of his salaries going down. Well, if you were a good lawyer, which you were, you'd be cross-examining the declarant, right? Are you talking about where he's going to play golf in his retirement? Are you talking about, is he going to have a hobby? Are you talking about, are you finally going to go do some work for the Southern Poverty Law Center and, make up for all the years of whatever?
Right, or are you going to stay with the firm? They've reduced your salary. I don't know what he's going to do. Is he going to stay there? Is he going to go somewhere else?
But we can't cross-examine the declarant. So it lacks materiality because of the vagueness of what is being said. I want you to focus on that as well.
Okay.
And then the other thing, which I think you mentioned, it has to be the only method of proving the fact. And so they're putting in some witnesses to say his salary is going down, Fisher and Phillips. Why does that have to be done with hearsay? They're going to bring the Fisher and Phillips lawyers in here and they're going to say, this is what his salary was. This is what his partnership draw is. Where's the necessity? We used to call it the necessity exception. 807 has it built right in.
Right.
And you will not hear from me again.
Until?
Based on their witness list next week.
We're going to get through what we can, and Mr. Rucker provided a prioritization. I think you said you wanted to start with Ms. Calhoun.
I think we got Stiles.
Oh, you said Stiles. You did say that. Okay. However you want to do it.
Can I speak to a couple points of law before we do?
Sure. Let's not get Ms. Stiles in here yet, please.
Simply because we're talking about what we want the court to be keeping in mind as we go. The courts have provided a number of different indicia of reliability that the courts can consider. And among them, of course, are the extent to which the declarant enjoyed a relationship of confidence with the witness. In fact, there is a case, Watson v. State, 278, Georgia 763. That's from 2004. Where the Supreme Court says that this court has consistently held that the statements of close personal friends of the unavailable declarant are admissible. So that indicates that what we have here is a rule that says there's all these caveats to admissibility, and of course the other side loves that because they can get up and say there is no situation when these could be admissible. What the Watson case tells us is that actually there's a fairly standard practice of when we're talking about people with a close relationship with the unavailable declarant, there is more of a history of courts allowing those statements in.
I noticed in Thompson, which is one of the cases that was flagged, they simply said, well, there were circumstantial guarantees of trustworthiness because it was an innocent phone call, I'm quoting, between the victim, who was the declarant, and a member of his fiance's family.
Well, they also say in the Thompson case, Your Honor, that the member of the family was a cousin and that they were like brothers and that was borne out by other evidence. So there was evidence of a closeness there.
But I'm agreeing with you that
Right.
it's almost these people were pretty good friends, so check that box and we'll move on. It depends on the case. There are other cases where in sort of excruciating detail they march through why the exceptional or extraordinary guarantees were present. But I'll look at Watson. Can you give me that site again?
Yes, Your Honor, that's 278 Georgia, 763.
Okay.
That's a 2004 case. It's been cited numerous times since then.
And you believe that that's importable to 807, even though that would have been the old necessity?
Yes, Your Honor.
Okay.
Many of the cases, there's not a one-to-one correlation between prior to 2013 cases and post, but there's enough that they are useful, and the courts continue to use them.
Okay.
But all that is to say that particular factor, the Supreme Court has taken the time to say, hey, we consistently find that this is a big deal when you're trying to assess indicia of reliability. Other ones that have been noted that I point out for Your Honor's consideration, the consistency of the statement with other statements made by the declarant, any motive they may have had to be untruthful, the voluntariness or apparent voluntariness of the statement, and any motivation to fabricate the statement. All of these we believe will show, when we bring the witnesses up here, that these statements were made to people with a close personal relationship to the victim, and that they were made in situations where there was certainly no motive to fabricate or lie. But as Your Honor pointed out, that there was the truth or the statements indicated something that will be material in this case, ranging from the very existence of a second will, which is not something that can be proved in any way except by the statements of the victim, Ms. McIver, because we don't have it, to the particulars of the changes which were contemplated back in 2011 and which were spoken about right up much closer in time to Ms. McIver's death. Some of those statements particularly concern what would happen with the ranch, and how there were changes in the air that specific in some cases that Ms. McIver wanted with regard to the disposition of the ranch that did affect the defendant. But another case I wanted to flag for Your Honor is just it's very new, and it's so new that I can only give the Supreme Court's case number.
That works.
It's Smart v. State. S.
299 Georgia 414. It's a different Smart.
Is that a 2016 case? Same
Yeah,
one?
299 Georgia 414.
Then they do have a site, and that's the same case, Your Honor.
Okay.
So what I really wanted to emphasize for Your Honor, that there are a number of different indicia of reliability the court can consider, because the point is always that it is a totality of the circumstances evaluation. The fact that the Supreme Court has emphasized the closeness of the witness on the stand to the unavailable declarant is certainly material here, but also there are other factors which the court can keep in mind. And I will sit down now because I believe Your Honor has heard several of them. But
I have a quick question for you, and if you're not the right person, let me know. In trying to streamline this, the one statement that you all are trying to get in through 807 that does now jump out at me as perhaps not meeting the second test or second prong, which is the necessity prong, is the one from Mr. Rickert, where Ms. McIver purportedly told Mr. Rickert that Mr. McIver's salary was reduced and she's not sure what he's going to do. How is having Mr. Rickert come in to recall what Ms. McIver said the highest and best proof that Mr. McIver was undergoing a financial shift? It sounds like there'll be lots of other ways that wouldn't involve hearsay that you could use.
that evidence is going to be presented by the state, and feel free to correct me, anybody from the state's trial team, but what that evidence actually shows is not simply that there was a change in the defendant's salary, but that Ms. McIver was aware of it herself. So we could bring in somebody from the firm to say his pay went from X to Y, But in order to demonstrate Ms. McIver's awareness of it and whatever impact that may have on the financial situation within the McIver relationship, we have to show that Ms. McIver was aware of the change and the impact it could have on the defendant, and that's what that statement goes to show. There is no other avenue to demonstrate that except her statement.
Okay. All right. Got it. So let's get Ms. Stiles in here, please. We're going to need to clear a path to the witness stand because I don't think it's practical to, well, I guess it is. It's just odd. Hello, Ms. Stiles.
How are you today?
Okay.
You raise your right hand for me. You swear or affirm that the testimony that you're about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, can you please state your name and spell it for the court? Speak loudly, please.
It's Rachel Stiles. It's Rachelstyles.
Hey, good afternoon, Ms. Stiles. Can you tell the court where you work?
I'm retired now.
And what did you do prior to retiring?
I did many things, but the most recent one was I worked for U.S. Enterprises,
Now, before we get into...
and that was part-time.
Before we get into how long you worked there, did you happen to know Ms. Diane McIver?
Oh, yes, many years ago.
And can you tell the court how long ago you met her?
I believe it was in the late 70s or early 80s, and I was invited to her company picnic. And this lady was dressed impeccable with a hat on and was definitely in charge. And I wanted to meet this woman. And when I did, we became instant friends.
And that was in the late 1970s?
It was either 70s or early 80s because I had begun to work for the Atlanta Braves. And that's the connection that we established at first.
And after you met her, then did that connection continue?
Oh, yes, many years until, September
Of 2016?
16. Mm-hmm.
Now, if you can tell the court or explain to the court your relationship with Ms. McIver as it evolved over the almost 30 years, over 30 years.
Well, I did many things for Diane. I was, when she would have parties, I would, assist her with that. I did, I was the wedding coordinator for Tex and Diane. I did plants and flowers for her, and I did errands, whatever Diane needed, she would call me and I would be glad to help her out.
And you did the wedding for Diane and Lieutenant McIver. You said you did plants. What did you do with her plants?
Well, she had a patio on both sides, 1501 and 1502, and I would plant seasonal flowers there, and then she had many plants inside the condo that I would take care of. And also I did a lot of plants at the ranch down in Edenton.
And you say you were able to water the plants in both condos, in one condo. Did you have a key to get inside?
Yes.
And were you able to, did you go in on your own?
Pretty much so, because usually Phyllis would be there. But, I did have access anytime I need to go. But it was always during the day.
And who gave you that key?
Diane.
And about how long would you say that you had a key to the Baptist condo?
Pretty much ever since they owned it.
How long would you say that was?
I don't remember.
You say more than 10 years?
Probably yes.
Now, how often did you see Ms. McIver over the years?
It would vary. I mean, we could go a month or 2 months and not see each other, and then I may see her every day, every week. It varied.
And tell the court how you would categorize your relationship with her. Was she a friend? Was she just someone that you worked for? time to time?
No, definitely a friend.
Did you consider her one of your best friends?
I would think so, yes, for the longevity of time we've known each other.
And did she talk to you about her coworkers?
Very seldom.
And did she talk to you about her godson, Austin Swall?
Oh, yes.
Okay. And what did she tell you about Austin Swall?
That, the first time I met Austin, he was in a bassinet, and we had met for dinner, and Diane comes in with a baby, and I was quite stunned. And then, she informed me that was her new godson. And they spent a lot of time together.
Did you continue to see Austin over the next 10 years with her?
Oh, yes, definitely.
Did she continue to rave about him to you?
All the time.
And how, over the years that you saw her interact with Austin, how would you say, or what's your impression of how she felt about him?
She and Tex both love that child with all their heart.
Now, at the beginning of your testimony, you said your last part-time job was at Corey Enterprises?
Yes, U.S. Enterprises, I think that's what my paycheck said.
Okay. And when did you start working at U.S. Enterprises?
I believe it was around September of 2011.
And at that point, in September of 2011, how long would you say that you had known Ms. McIver?
Well, since the late 70s, early 80s.
A long time.
Yes.
And why were you working part-time there?
The receptionist, office manager, was going out for back surgery, and Diane had called and asked if I would come and help him out for about 4 to 6 weeks. And that 4 to 6 weeks was almost 4 years.
It was supposed to be temporary, but it turned into a good part-time job.
I enjoyed it very much.
Did you work day in and day out with Ms. McIver when she was in the office?
Not really. I mean, we interacted a lot, but she had her own personal assistant, so she would ask me to do things if he wasn't around, or, if there's something special she wanted done in the office, she'd come and ask me if I would take care of it.
And over those 4 years, did you ever have a conversation or an interaction with Ms. McIver about the will?
One day Diane did ask, excuse me, to make some copies, and she says, I can't trust anyone else. I would like for you to make me 2 sets of these papers. So I go in the copy room, face down, make the 2 copies, go back into her office, and when I handed them to her, she thanked me, and she says, this is my new will.
She said what?
This is my new will.
And after she said that, did the conversation continue or did it end?
It ended. I went back to my desk.
And where were you when you made these copies?
In the copy room.
At U.S. Enterprise?
Yes.
I know it sounds like a silly question. And who was present at the time that this conversation occurred?
Do you mean in Diane's office or in the? I'm not sure, because it was around lunchtime that, and so quite a few people were out for lunch. So I don't recall exactly who was in the office at that time.
Let me ask a better question. Who was around the two of you when she asked you to make the copies and when she told you this is my new will?
Nobody.
So it was just you and Ms. McIver?
Right.
And then after you made those copies and brought them back to her, did anything happen next regarding her new will?
No, she just thanked me, and I went back to my desk.
You went back to your temporary job?
Yes.
No further questions?
Ms. Stiles, I have a question, and then Ms. Clark-Palmer is free to follow up. Can you put that conversation somewhere on a calendar when Ms. McIver asked you to make the copies and said, this is my new will? in relation to when she passed or how long you've been working there? When would you say that was?
I can't remember exactly because I had no idea what I was making a copy of, so it was very insignificant to me, so I didn't really make a mental note that it was that important.
Okay, I hear you on that. Would you say that it was a few months before Ms. McIver passed away, or 2 years before, or you're not comfortable putting a date range around it at all?
Well, I would say it's at least a year and a half or 2 years.
Before?
Yes.
Okay, thank you. Ms. Clark-Paul? Not quite, apparently.
Thank you, Judge. Ms. Stiles, my name's Amanda Clark Palmer. You and I have talked on the phone, but we haven't actually met. Right?
Nice meeting you.
Yes, nice to meet you too. At the time that Ms. McIver asked you to make this copy, was that at the time that U.S. Enterprises was selling one of the billboard companies, or something was going on within the company?
They were the outdoor billboard company. They were in negotiation to sell those.
At that time that she asked you to make those copies?
Right.
And there was a concern that if other people at U.S. Enterprises found out the details about the sale, that they might then leave the company or do something that would negatively affect the company in some way, right?
Well, that's the way I sort of interpreted it, because I had made some copies earlier in reference to the sale, and that's why I think she said I can't trust anyone else.
Because she didn't want anybody else at work to know whatever was in that document.
Absolutely.
Okay. And at the time working at U.S. Enterprises, do you know who Kenneth Rickard is?
Yes, I do.
And is he Mrs. McIver's, was he a lawyer for U.S. Enterprises?
Yes, sir.
Did he also do, if you know, legal work for Mrs. McIver?
He was sort of the legal representative for everybody there.
Including Mrs. McIver?
Yes.
Okay. Was he working there at the time you made copies of that document?
Yes.
Okay. And do you know who Elaine Williams is?
Yes.
And is she a paralegal at U.S. Enterprises?
Yes, ma'am.
Okay. And if you know, did Diane McIver know who Elaine Williams was?
Oh, most definitely.
Because they worked closely together?
Yes.
And Elaine Williams was working at U.S. Enterprises at the time Diane McIver asked you to make a copy of this document?
Yes, ma'am.
And do you know Terry Brown?
Yes.
And Terry Brown is was Mrs. McIver's kind of personal assistant?
That's correct.
Okay. And was he working for Mrs. McIver at the time that she asked you to make copies of that document?
Yes, ma'am.
Okay. And do you know if Terry Brown was privy to Mrs. McIver's financial information?
I believe so, yes.
Okay. And at the time you made copies of this document, is it your memory that the document was approximately 2 to 3 pages long?
I believe it was more, it wasn't a big document. It was approximately 2 to 3 pages.
You know it was more than 1 page?
It was more than one, but it wasn't 10.
Okay. And to the best of your memory, it was 8.5 by 11 size paper, right?
Yes, ma'am.
And it appeared to you to be just kind of plain paper, right?
Yes, ma'am.
It didn't seem especially heavy or like cardstock or anything.
No, ma'am.
And the pieces of paper were not fastened together in any way.
No.
And they didn't have like a blue backing paper on them.
No.
You didn't see the title of the document, right?
No.
You don't know if there was any handwriting on the document.
No.
You purposefully did not look at the document, right?
That's correct.
Because you interpreted Mrs. McIver's comment, I can't trust anyone else, that this was something she didn't want anybody to know about, right?
I presumed it was because of the possible sale of the billboard company.
So you made the conscious decision not to look at the document and see what was written there.
Well, when someone tells you that you're the only one they can trust, you certainly don't want to ruin your trust by looking at a document that is private.
Okay. You didn't want to lose Diane's trust, did you?
Oh, absolutely not.
And you told us that you made only 2 copies, right?
That's correct.
And it's quite possible, isn't it, that Mrs. McIver was not being honest with you when she said that was her new will? Isn't that a possibility?
I don't know why she would have mentioned it anyway if it was not, she was the one that made the comment. I did not prompt her in any way, and I didn't ask her what the contents was.
But it's possible that the document related to something else she wanted to keep confidential, like the sale that was going on with the billboard company.
It could be, yes.
I'll sustain it, and you're free to argue that when we talk about this more. You may. Are any of the attorneys for the media here? Hello, hello. We're going to talk with you guys in just a little bit. I appreciate you being here.
Okay, those are all my questions, Judge.
Okay. Any follow-up, Mr. Abate?
Just to be Your Honor. Ms. Stiles, we talked several times over the last year and a half. Yes?
That's correct.
Do you remember telling me on a previous occasion that you made copies of this new will a year before Mrs. McIver's death?
I'm not sure it's the exact date, but it was at least a year or more. I don't remember the exact date.
And do you remember telling me that the document that you made copies of, and Mrs. McIver said it was her new will, was several pages long?
That's correct.
Nothing further
All right. May Ms. Stiles be excused?
for today. Yes.
Sure. Thank you, ma'am, for being here.
Thank
Appreciate it. All right, who's next?
Danny Brown, Your Honor.
All right. All the way up here, Mr. Brown. Thank you. We're going to try to chart a clearer course for witnesses so you don't have to do a maze. Did well.
Do you swear or affirm that the testimony that you're about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, can you please state your name and spell it for the court and speak loudly?
Terry Brown, Terry Brown.
Good afternoon, Mr. Brown.
Good afternoon.
Okay, are you currently working?
No, I'm not.
And can you tell the court where you worked previously?
U.S. Enterprises,
And when did you start working with U.S. Enterprises?
August 16th, 2010,
And how long did you work at U.S. Enterprises?
until January 31st, 2018.
So roughly 8 years.
7.5.
And when you were working at U.S. Enterprises for those years, what was your role?
I was executive assistant to Mr. Corey, Diane McIver, and Richard Harrell.
And who did you work primarily with?
Primarily Diane. I was also her personal assistant. I did a lot of her personal things as well as business.
And did you do that for the entire 7 years? prior
Yes.
to McIver?
Yes.
And as her personal assistant over those years, what are the kind of things that you would do for her?
Everything that it took to get her through the day, basically. I mean, I didn't pick up her laundry and I didn't do her grocery shopping. Other than that, I did pretty much everything.
And I know you say everything, and I know you know, but the court doesn't know. So what are some of the things that you would do on a daily basis for and with Ms. McIver?
Okay, I kept track of all of her financials for her personal as well as claim management. I ordered her clothes. I ordered her makeup. I ran the houses, the ranch, as well as the condo at Kingsborough. If something was broke, I was the one that set up the repair schedule. Didn't go there to actually make sure it got fixed, but called the staff at the houses to make sure that they knew that somebody was coming to do whatever needed to be done. I picked up her lunch every day.
And over those years, did you spend a lot of time with her?
Yes.
And you said one of the things that you did was you kept track of all of her finances or financials.
Correct.
Did she share that financial information with anybody other than you?
No.
And tell me a little about that.
Literally, I collected her bills because I got her mail. So if a bill came and I knew it was a bill, I opened the bill, and we kept a folder in her office, and the bills were kept in her office. About twice a month, I collected the bills, sat down and figured out where her money was and where it needed to be. And I started work at 8. She didn't start till 10. So when she got in the office in the morning, I would say, okay, today is bill paying day, and you got to transfer money from here to here to here, and here's the bills that you need to pay.
And did you have access to her checkbook?
I had access to her accounts online. I knew where her checkbooks were, but I was not an authorized signer on the account, so I couldn't sign a check, but I could pay it online.
And did you pay online?
She preferred to pay her own bills. I did check behind her, and if she paid out of the wrong account, I would go over to her and tell her, and generally I would fix it if there was an error.
And did you have the username and password for all of her online accounts?
Absolutely.
And did she share that with anyone other than you?
No.
And how long did you have access, or it sounds like sole access, to all of her financial accounts?
When she hired me in 2010, she still wrote checks. It was probably sometime in 2011 that we went to online banking. So from 2011 on, when she was writing checks, I didn't have access. It was my suggestion that we move to online banking, so we didn't have to write the check, because she only signed the check. I had to fill it in for her, and it was easier for me to do it online. So I convinced her to go to online banking.
So for all intents and purposes, you actually wrote the check she was signing?
Correct.
And was she very private about her finances?
Absolutely.
Did Tex know about her finances?
No.
How do you know that?
As far as when she hired me, she told me she ran her business like a marriage, and what was hers, and what was his, and the two would never meet.
I'll
And
make sure I followed what you said, because maybe you flipped words around. You said she ran her business like a marriage. You meant marriage like a
marriage like a business. Yes, I'm
Okay.
sorry. Yes, I'm
Okay.
sorry. Yes, yes,
Did you know Austin Schwall?
yes.
And who was Austin Schwall?
Judge and Anna Schwall's son.
Did you know how Diane felt about Austin?
Yes.
Can you tell the court how Diane felt about Austin?
Pretty much like a mother feels about her child. I mean, I would say that that's how she felt about Austin. And she had him 4 days a week.
4 days a week.
Yes.
And do you know when when she came into Austin's life?
He was already born when I was hired, but from the stories I've been told, she used to bring a bassinet into the office, and he spent days in the office as an infant with her. Now, I wasn't there, so I can only say what I was told.
Now, while working at U.S. Enterprises, did you and Ms. McIver have an opportunity, a conversation, an interaction about her will?
I know I had her will. I never questioned her about what she was doing. When she gave me something and I just took the task to what I was supposed to do, I know I had her will in my office at some point in the last 2 or 3 years. My assumption was that she was making changes to it, but I don't know. But it was in my office. I had her will.
Now, you remember telling me that she gave you her will and said, I'm making changes to it. Will you hold on to it?
I wouldn't have held on to it. I know she was making changes to it, but she didn't like me to keep things in my office because people would come in my office and go through things. So things were not allowed to be kept out. So if I would have had it, and I know I had it, I would have given it back to her before the end of the day.
And is it your recollection that you gave it back to her?
Yes.
And from what you just said to the court, was that in 2014, 15?
Somewhere in that time frame. I don't remember the actual time frame, but it was in the last couple of years, yes.
Why did you say you knew she was making changes to it?
I believe that's what she told me when she gave it to me. I just don't remember why I had it, because I wouldn't have made the changes.
Okay.
And was that the only conversation you had with Ms. McIver about any sort of will?
Yes.
McIver socially.
Yes, I did.
Okay. And tell me a little bit about that.
Dinner probably once a quarter. I was invited to birthday parties for Tex. I gave Diane a birthday party every year from when I thought she was 60 until she was deceased. And they were at my house with her friends. And of course, I planned Austin Swall's birthday party every year, and I was invited to that at the ranch.
Any other questions?
Okay. Ms. Clark-Palmer.
Maybe a third before I cross? Or either that or ask Mr. Brown to step down?
Yeah, Mr. Brown, if you don't mind stepping outside for a second, we'll get you right back in here. You remain the witness of the moment, but we need to talk about something that will get you back in here.
Okay.
Thank you. Same windy way out was your way in.
We're going to adjust.
Good. Ms. Clark-Palmer.
Your Honor, what I heard Mr. Brown say is not the same statement as what was provided to us in the 807 notice. So I don't want to start cross-examining him on a statement that we've not had any notice we were going to be dealing with.
I hear you on that. I actually heard both Mr. Harvey and Mr. Samuel say, not quietly, that's not what was in the notice. So I figured this is what we'd be talking about. And one reaction is, well, you're right. That is not verbatim what was said. In fact, the word new wasn't used at all. It was changes to will, which is a different flavor and tenor. We've got the witness here. Why don't you ask him about it? We'll work through I agree there's a disconnect. And that's confusing to me, and we can work through that. But I don't know that you want to forego your opportunity to ask Mr. Brown about this situation, because it sounds like what we heard about, I had this document for one day, I'm not allowed to keep the document in my office, is the moment that the state's focused on. There's just now something different being said, which may lend itself to one of the factors that I'm supposed to be evaluating. Can we have Mr. Brown back, please? Liz? Please.
Okay. Mr. Brown, my name is Amanda Clark-Palmer. I represent Mr. McIver. I think you and I have spoken on the phone before one time, maybe?
Yes.
Okay. Nice to meet you.
Yes.
So I want to make sure I understand what you just said. There was a moment in the last 2 or 3 years, and I think you mean in the last 2 or 3 years before Mrs. McIver died,
Yeah, before 2016, yes.
where did she hand you a document?
Yes.
Can you describe the document for me? Was it a thick document or thin? Was it stapled? How would you describe it?
It was stapled.
How many pages? Can you just give me a guess?
I'm gonna say 10 pages.
Okay. Do you think it was this size paper, 8.5?
Oh yeah, it was definitely that size paper.
Did the paper feel like just kind of normal copy paper?
Yes, it was normal copy paper.
Did you see if there was some kind of title on the document?
All I know is, because I didn't read her stuff, all I know is the front page said it was a last will and testament.
Okay.
But other than that, I can't tell you anything about anything that was in what I had,
Why did you not read her stuff?
because she didn't give me permission to.
Okay.
And that was our trust level.
Okay.
She knew she could give me something, and I wouldn't nose into her business. I don't know how else to say that, but.
Okay. And what did she say when she handed you the document?
That she was making changes, I believe, is what she told me.
Okay.
But I don't know why I had it, because I wouldn't have been the one to make the changes. So I honestly don't know why I had it, but I know I had it. I don't know why.
Okay. And did she say anything to you when you gave the document back at the end of the day?
No.
All right.
If she did, I don't remember, so I don't know. So I'm going to say no, but I don't remember.
Okay. Did she discuss the changes she was making with you?
No.
And do you know who Ken Rickert is?
I do.
Who is he in relation? Well, is he a lawyer for U.S. Enterprises?
Yes.
Was he also a lawyer for Diane McIver? Do you know if he did any personal legal work for her?
Yes, he did.
Okay. Can you describe what their relationship was like, if you know?
A professional relationship. I mean, if she needed legal things done that were, she knew he could handle, he did those. When she made her loans, Ken drew up the papers because she loaned money, but she always had a legal document, and he prepared those legal documents.
Okay.
To whom did she loan money?
A lot of her friends.
Okay.
Did she also loan money to the company, U.S. Enterprises?
Yes, she did.
And to Mr. Corey? Do you know?
To my knowledge, not to him personally, no, but she did loan money to the business. Well, to a specific business. The Dallas airport was a joint venture project with Corey Airport Services and two ladies in Dallas, and she loaned money to the joint venture.
Okay.
And it's in the documents that it's in her banking because that was, she wrote a check.
Separately from that, did she loan money to U.S. Enterprises?
Not to,
Yeah, I wasn't opening a new can of worms. She said loans, and I was curious if it was personal loans or if these were business loans, and there may be some other time you want to explore it with him, unless you think it's germane to what we're focused on right now.
You made a comment that, or you were asked if anybody else knew her user ID and password for her online banking information, and you said nobody else had that information.
correct,
How do you know that?
because I created them,
Okay.
and I'm the only one that had them.
Did she know her online user ID and password?
Yes,
Okay. So you're assuming she didn't share it with anybody else, right?
yes,
Okay. Same thing, you were asked if Tex McIver knew about her finances, and you said he didn't know.
no, he did
Can
not.
you explain your basis for making that statement? Because she
Correct.
told you she ran her marriage like a business, right?
Correct,
But you're assuming that Tex and Diane never talked about their finances out of your presence, right?
correct.
Was there a time when U.S. Enterprises was in negotiations to sell part of the business?
Yes,
When was that?
2017.
Okay, how about before Mrs. McIver died? Was there,
Oh, yes. Everything was always for sale at U.S. Enterprises, if they could find a buyer. So, but the billboard business was on the market, and Diane told me that herself. They were looking for a buyer to sell the billboards. The airport services, she was not interested in selling. That was what she created. It has since been sold, but she would have never sold that.
when did she make that statement to you about wanting to sell the billboard, or they were interested in trying to sell the billboard company?
I would say somewhere 2014, 2015, and the building itself has been up for sale since I've been there.
Okay. Can you relate when Mrs. McIver handed you the document and said, "This is my will"? Can you relate that in time to the 2014, 2015 sale of the billboard company? Was it the same time?
Well, it didn't sell. It was just for sale.
Right.
It didn't sell till 2017.
Okay.
I don't know. I mean, I don't know.
Okay.
Anything else, Mr. Abate? Okay. I didn't, she may not be done.
All right, thank you.
Okay.
Mr. Brown has a few more questions. After Mr. McIver passed away or died, did Mr. McIver come to you for help concerning Mr. McIver's finances?
Yes.
Did he come to you for help as how to get into these online accounts?
I don't believe he even knew where she banked.
And did you tell him where she banked?
Yes.
Did you provide him with the username and passcodes to get into the online banks and other financial institutions?
No.
Okay.
Actually, when she was deceased and the bank found out, they locked them, so him having the user IDs would have done him no good.
Through your conversations, were you able to gauge whether he knew or didn't know the usernames and the passwords?
Like I said, he didn't even know where she banked as far as I know. I could be mistaken there, but I had to give him the banks and the account numbers and
Where did Ms. McIver keep all of her important papers at U.S. Enterprises?
In the lock cabinet in her bathroom.
In her bathroom?
Yes.
And after Ms. McIver's death, what happened to that cabinet and the papers within it?
A locksmith was called, the cabinet was opened, and then, as far as I know, Angie Brooks, Ken Rickard, and Mr. Corey went through the cabinet the day it was opened.
And what happened to the papers inside of the cabinet?
I can't answer that. I know.
What happened to all of her? Do you know what happened to all of her stuff in her office?
All of her stuff in her office was boxed up and put in the warehouse, and Tammy Johnson came with a pickup truck and hauled it off.
And who's Tammy Johnson?
She, at the time, was working with Tex on the estate.
And did those boxes contain a lot of Ms. McIver's financial documents?
Okay. The financial stuff was not in her office. Those boxes, I created a box every year that I worked for her, labeled for the year. It had her check registers for every month for each bank account, with the bills for that month, with the bank statements for that month, all put together and bundled by year for her personal, for claim management, and we kept her American Express statements separate because they were used for business and personal, and they were in there in order by month and how they were paid, and there was a box for each year. I created those, and there were labels on them with what was contained in them. The other boxes were packed up, I guess, by Angie Brooks, Ken Rickard, and Mr. Corey, and they were just haphazardly boxed up and hauled away.
Do you know where they were hauled to?
As far as I know, they were taken to the condo. I helped Tammy and Dixie, Tex's sister, load the boxes into the truck from the warehouse, and I think they took them to the condo, but I don't know where they took them.
Can I follow up briefly on that?
Sure.
Mr. Brown, did you see that Mrs. McIver kept financial information that went all the way back to the early 90s? Do you know?
I know from 2010 forward, I know she had stuff in a closet, but I can't answer if she had I don't know that she had financial stuff back to the 1990s.
Okay, but you just told us that you kept her check registers, her bank statements, her credit card statements, right?
Correct.
Okay, she kept those types of documents for her records, didn't she?
I don't know why she kept them. I put them in a box and gave them to her, and she hung on to them for whatever reason she had.
Okay, fair enough. You did that because she asked you to do it?
No.
Okay, that was just your initiative to keep all those documents?
That was my initiative to make sure that if she needed that for her taxes and stuff, it was in order by month, by what she did, and how it was arranged.
Okay, thank you.
And Mr. Brown, step down. Thank you, sir. You are released for today, but don't go too far.
Okay.
Thanks. I'd like to spend a few minutes talking about the motions to quash. So we're going to shift gears to the media subpoenas. There really isn't space for you all at the table, but you can come on up. I don't know that this will take real long. I have a few questions basically for the state that ought to be answered in your presence. And then I think we'll pivot back to 807. So who's going to be speaking for the state? Once again, Mr. Wakeford. Okay. And Ms. Counts, how are you?
I'm good, thank you, Your Honor. How are you doing?
I'm well. Are you here for both what I'll call the Fox 5 and the Daily Report, or just Fox 5?
Both, Your Honor.
And you are?
I'm Leslie Gaither, Your Honor. We had a similar motion for the former General Constitution reporter Craig Schneider, and then Mark Liddy from WSB-TV that I learned on the way down here was misfiled. It was served on everyone. So
That explains why I don't have it.
that did. So
Okay.
I have several copies, but when I kind of admittedly saw on Twitter that this was happening, I rushed down here to try to sort it all out.
Wow, we're on Twitter. You guys are welcome to sit. Some of the prosecutors graciously stepped, if you want to sit in those comfortable seats for a moment while Mr. Wakeford's talking. But this will sort of be just a back and forth. I don't think we need to hear from the defense at all. This isn't their situation. But I'm sure one of them will pipe up if they need to be heard. What I want to understand from the state is, number one, what exactly it is you are trying to get. At a minimum from Fox 5 and the Daily Report. I haven't seen the paperwork as to AJC and Mark Winnie. I'm guessing it's similar. And then I have read Ms. Counts' motions and learned a little bit more about how, I'm going to call it 508 for short, how 508 works and how our courts have applied it. And I think a lot hinges on exactly what you want. If you just want someone to authenticate, this is our video, I don't know that we need more states to do that, and I don't know that the defense would object to authenticating, not committing them to anything. But with what you're looking for is the whole recording, only parts of which were broadcast. That seems like a tough road to hoe in light of precedent that we have here. And that threshold, we'll have you talk to the public information officer who might have been standing within earshot of Mr. McIver the whole time he was talking to Morris Diggs or Mark Winnie, things like that we got to work through. Because if the answer is no, I can let these attorneys go home, only to return if you can then convince me that, yep, we have exhausted all other possible sources of info and we are back to then working through how do we balance the equities. Okay?
Okay, Your Honor, first thing, I'll start right off the bat with a citation. This is In re Morris Communications.
Sir, can you mic for me, please?
Yes, ma'am. This is In re Morris Communications Company.
Great.
That is 258 Georgia Appeals 154. And this is one of these cases that interprets the statute at issue, or a predecessor version of the statute, and it actually cites to the In re Paul case, which is included in, I believe, the motion to quash that we do have a copy of.
Yeah.
What this case basically, the reason I'm putting this forward right off the bat is because that case speaks to a lot of the issues that are present here, which is that the investigation that the state is going into with regard to these reporters is not very deep. Essentially, there were statements made either by the defendant's representatives, specifically, I believe, Mr. Crane, or by the defendant himself, especially with regard to the interview given to Mr. Diggs from Fox, where the source was either the agent of the defendant or usually the defendant himself.
Sure.
Mr. Diggs is a good example. He gave a televised interview, or provided a televised story, where he went and spoke with Mr. McIver. And in addition to providing quotes directly, a video of Mr. McIver making certain statements, he also summarized between, saying things Mr. McIver also says, and then summarized, and then the quote would, the next time you heard Mr. McIver speak, it would be moving on. All the state is trying to establish is something that nobody else can establish, which is Mr. Diggs to say, I heard Mr. McIver say that. He is the source for that information himself.
Okay.
That is as far as these statements are going to go, as far as the evidence is going to go from the state's perspective with regard to these reporters.
So two things about that. One, to your argument would be, we're not trying to, well, the privilege has been waived, I guess you'd say, as to that, because Mr. Diggs is saying, and he told me X. But on camera, it's Mr. Diggs saying McIver said X. And so the fact that McIver purportedly told Diggs X it's out there. That is what Fox 5 ultimately elected to publish, but instead of McIver's mouth moving on the screen, it's Diggs's mouth. What you're not trying to do, if I understand it, is to say, we want the whole recording, even that which wasn't broadcast, because there could be some interesting things that were said that didn't get broadcast, which I think collides pretty hard with precedent. And I don't think you'd be authorized to ask Mr. Diggs Well, did he say some other things that you chose not to publish? You agree?
I don't make a representation either way on that, Your Honor, because the state isn't asking for any of that. We're asking for confirmation of what, as Your Honor put it, has already been waived because it was put out in public. And that's what the Morris case, which I cited to Your Honor, speaks about, is specific instances when the privilege either has been waived or the qualified and not utter nation.
Is Morris the case where Judge Kell, I don't know who the judge was, but all they wanted to do was confirm that these are the only 2 articles that were published?
Yes, sir.
Because that would help them show he can't, defense was, oh, I read about it in the newspapers. But if the only 2 articles didn't include this factoid that the suspect was sharing, then that undercuts the suspect's claim that the knowledge I have came from the media. And so it wasn't going outside, we'll call it the 4 corners of the reporting. Just, are these your articles? Yes, they are. And are these the only articles you published on this?
Yes, Your Honor, that is the Morris case.
All right. That's for Mr. Diggs. What about the daily report?
Well, this is where I started getting in trouble, Your Honor. I'm not sure exactly what is contained in the daily report, but what I can tell you, Your Honor, before this is clarified by Mr. Rucker or someone else, is that in all cases, that is what the state is asking. We are not asking for a more complete or confidential record of what has not been put in the public domain. It is simply the only person who can tell us this summary of the defendant's statements, this provision of the defendant's statements. Those were given to you directly by the defendant or directly by Mr. Crane himself.
So, okay, I guess I'll need to understand more about the daily report because that is print. And so it says what it says. And I guess the parallel would be some things might have quotation marks around them, and then Ms. Hobbs in other parts of her article may not hang quotations on something, and you're just wanting to confirm that the other things you're writing came from the people you were quoting. That will make it more complicated for you, but.
Well, as the court knows, and I'm sorry, Judge, but
if this is more efficient, let's do it this way.
As the court knows, the defendant is charged in a county indictment with attempting to influence Mr. Bill Crane. And so what we're talking about is this daily report article. This is the source of that count. This is what we're talking about. And the state's position is that the defendant talked to Bill Crane and said, this is what happened. And I authorize you to release these statements, my words, to the media. The media that Bill Crane was releasing them to was the AJC, the Daily Report, and it was the third publication. Bill Crane, I expect, will come in here and testify and say, hey, I had communications with Meredith Hobbs, and I told her this is what Mr. McIver says happened, and I'm authorizing you to release it. Meredith confirms the statement by saying back to Bill, hey, this is what I'm going to print. Look it over, is it okay? I expect Mr. Crane to say, hey, I ran this by Mr. McIver, and he gave me the authority. Yep, that sounds good, it's okay. I tell Meredith, go ahead and run with the story. She prints the story. There's some backlash. There are things contained in the story that are inconsistent with things that Mr. McIver said to the Atlanta Police Department. And Bill Crane starts to get pushback from Steve Maples and Mr. McIver himself to say, hey, you need to...
I'm familiar with that part.
You got that part.
So why can't Crane do everything you need with what you just described?
Because I think that the question is whether or not what Mr. Crane was told by Mr. McIver is actually what Ms. Hobbs printed. And so yes, Bill Crane can say, yeah, I'm looking at it, this is what I told her, but I guess my position would be that Meredith Hobbs could corroborate that, because Bill Crane's credibility will come under attack.
But, so Meredith Hobbs would be called in to say, my article reflects what Bill Crane told me, and Bill Crane told me, Tex McIver told me to tell you this.
Right, and I didn't insert any of my own verbiage.
Okay. So let me hear from one of the media attorneys now that this is, that may be exactly what was in the subpoena. I haven't looked at the subpoenas, but it sounds like that is putting some lines that weren't there before. What's your reaction? Let's start with Fox 5 so we go in order.
Sure. Your Honor, I think that the problem is that we're jumping over. I mean, the idea is that this is necessary and that these are the only witnesses. And having been here today, I've heard a lot of testimony about statements that were made with law enforcement, et cetera, et cetera. There's a lot of speculation as to what's going to be said, what would have been said. They're allowed to have what was published. And then to go behind that, it needs to be that they've exhausted every other resource. It can't be that we're the most powerful evidence. Everybody wants the reporter to come in, but the cases are pretty clear. That would be just cumulative. It's not necessary. And this is not a Sixth Amendment right. This is the state asking for information. So it's the public's right to information, evidence, against their right to, concerning evidence against the right to information.
So I hear you. I promise I read your motion. I get all that. But if all the state wants, if I limit the state to being able to ask Mr. Diggs, we're starting with the Fox 5. We're not even getting to the completeness issue yet. That's a defense argument.
Right.
If the question for Mr. Diggs is, hey, let's watch your report. All right, Mr. Diggs, you just said Tex McIver thought it was cold the night of the shooting. Is that what Tex McIver told you? I mean, he has said, and it sounded like it was even less of an issue, not the media attorney. It sounds like it's Morris Diggs saying, Tex McIver said it was cold that night, but it's Morris Diggs saying that. So what is where are we running afoul of 508 if Morris Diggs is called to the stand and is asked, is that in fact what Tex McIver told you?
Your Honor, well, I think it kind of skips over. We have to think about the policy, right? The policy is that reporters need to be available to report. They don't need to be investigative arms of dissent offense or the state. Right now, Meredith Hobbs is having to sit outside because of sequestration of witness rule. So it does interfere. It also creates a spectacle. And so the rule, I think, is smart. First, is it material and relevant? Well, is it? I don't know. It seems like if there are other people too, is it really necessary? You've got other witnesses that can say the exact same thing. That's why you have to exhaust resources first. So even starting with that phone call.
But isn't that if it's, I'm asking you to tell me why the privilege covers it. I'm agreeing.
Oh, the waiver, the Morris issue, right?
Exactly.
Okay. If we stick to just that, I think there's a footnote in Leslie Gaither's brief that talks about the ways that you could authenticate this with a custodian affidavit. Clearly, that is the standard. Now, when we talk to the state, they do say they want to get behind the circumstances. Let me ask you this, Your Honor. We had Mr. Maples here earlier today. He could have been called to the stand. He could have been asked whether it was, who was talking? Was it the agent talking, the attorney, or was it the defendant? And even so, how is it really material to whether or not he murdered? And how is it necessary to the proper presentation of the case?
But I know privilege doesn't apply. I don't have to march through material reasonably obtained by alternative means. And so what I heard Mr. Wakeford saying is we don't get to the privilege because we're not going outside the scope of what was published. And so what's published isn't privileged.
In this case, Your Honor, just since he speculated a lot about what would be in that information, let's just think for a second. Do you expect that an attorney would allow his client to talk about the circumstances of what occurred when he's sitting right there with him? I mean, and that is going behind what was published. What was published is pretty clear. He's talking to both the attorney and to the defendant. The defendant's quoted. Logically, too, probably Fox 5 would hear whatever they had that he had to say. But that's why I'm asking you to consider the policy. Because here we are, a lot of time, when it just what was said in that section. And you could encourage them strongly to authenticate it, to stipulate. I've talked to the defense, my understanding is they wouldn't have a problem. And so the question is, how important is this evidence that Morris Diggs come here and testify about whether the attorney said it or whether the defendant said it, when we have Mr. Maples who we can ask.
How about the daily report one?
The daily report one, I mean, there's no comments from the defendant whatsoever. It's all about what Mr. Maples or Mr. Crane said. Again, they can be asked. Also, there are many friends, there are many other sources of information. That's what we're talking about. This is about whether or not, that one goes out to Diggs. Diggs is about whether or not he had a sleep disorder. Well, you could get the Mayo Clinic records for that, I guess. You could get medical records. You could get other sources. I mean, it seems to me to be a joke putting the cart before the horse, that we're getting into all of this stuff. The other one is about impeachment. So before you do impeachment, you need to have them get on the stand and make certain that there's a need for impeachment and that it is necessary to the presentation of the case.
Okay. Do you represent anyone else, or you just have a daily report in Fox 5?
Just those two, Your Honor, she represents the other two. I will say, though, Your Honor, in terms of just how important this is in relevancy, I certainly don't know a lot, but the questions have been whether it's intentional or accidental, right? And there are numerous other witnesses, driver, the dying declaration, Tex McIver, Tex McIver gave statements to police. What do these reporters have to say about that? Whether or not there's physical evidence showing the car, the autopsy, the guns and ballistic being tested. Why do we need hearsay on hearsay in this murder trial of media to make it more respectful? You have the other co-worker, neighbor's friend, or inmate, prison guards. He didn't even mention the PIO officer. Whether or not he's followed through, like the state said, he's exhausted everything else he could. And we would ask, Your Honor, that he does. And that's just policy to protect the trust.
Okay.
And Your Honor, just one thing, remember the Richard Jewell case? Even when the privilege didn't apply, before they gave confidential information, the court was really reluctant and required other necessary aspects of the case to be proven first. So even when the privilege doesn't apply, I would argue that stands too.
Okay.
Thank you, Your Honor.
You're welcome. Did you want to add anything?
Very briefly, Your Honor. And again, I apologize. We can refile our motion or we can present it to the court. However, Your Honor prefers, I have it with me now.
I'd love a hard copy at some point, but you can do your talking now.
With respect to Craig Schneider, the Journal-Constitution reporter, Mr. Schneider actually lives in New York. He doesn't even live here. The articles are self-authenticating under the evidence code. I hear what Your Honor is saying. If they are only talking about the articles, then somebody can authenticate the articles, but that's not a privilege issue. But we would submit, but we could not get that information from the state, exactly what they were looking for Mr. Schneider, and I don't blame them for that. But so we kind of filed an abundance of caution there. But anybody from the paper can come authenticate articles. We shouldn't have to bring somebody in from New York to authenticate newspaper articles, especially when they are similarly what Mr. Crane said, what other people said. With respect to Mr. Winnie, we did...
Did Mr. Winnie, he also had a jailhouse interview?
Mr. Winnie had a jailhouse interview. Again, we would submit that anybody from the station could authenticate that if it...
Okay, but if it's beyond authentication, I want to press you on the same issue I was pressing Ms. Counts.
Sure.
Mr. Winnie, if the Channel 2 footage was for a while, here's Mr. McIver talking, answering questions, and then Mr. Winnie, because sometimes that's the style, says, and Mr. McIver also told me, 1, 2, 3. That's Mr. Winnie saying that. Why shouldn't the state be able to ask Mr. Winnie, is that what Mr. McIver said when you interviewed him? That's not going into sources because, of course, Mr. Winnie identified his source, Mr. McIver, and it's not going into unpublished material because Mr. Winnie said publicly, Mr. McIver told me 1, 2, 3. Why shouldn't they be able to ask him that to explore or get around a hearsay concern or whatever the issue might be?
I don't disagree with you, Your Honor, necessarily. They should be able to. I don't think that's in Mr. Winnie's interviews. I think there are 2 broadcasts there, and I believe it's only Mr. McIver making Mr. McIver statements. I don't want to say that to 100%
Okay.
because be wrong, but I don't think there's that issue there. And even Mr. McIver's statements, and there may or may not be a relevant concern, is things like the jail is nice, so, but that's for these folks.
Otherwise, yeah.
Thank you.
Okay. All right.
And may I approach?
Sure, you give it to Ms. Lyon. That's great.
Ma'am, can I have your name, please? Your name? Oh, yes, I'm Cynthia Count, Counts. Thank you.
Anything you want to say in wrapping up the state side of things?
Well, I think Your Honor's got the important aspects of our argument with regard especially to the televised interviews directly with the defendant. I just want to emphasize that to the extent that Mr. Crane's statements are discussed here about print articles, Mr. Crane's credibility is a material and central aspect of one of the charges in this case. And establishing, again, something that has been waived, something that was included in the article, simply bringing the reporter or having the testimony or even stipulation, if that's something that can be agreed, to show that the reporter published the thing that was said to them by Mr. Crane.
Do you know if Mr. Crane provided a written version or he merely orally relayed to Ms. Hobbs and everyone else? Here is the statement of Mr. McIver through his publicist, Mr. Crane.
I understood that a written version was created, and exchanges went back and forth to make sure it was accurate, and that it was actually shown to the defendant before Ms. Hobbs got the authority from Mr. Crane to publish it.
Okay.
So I guess my answer to your question, there's a written version of it. I've never seen or received the email, but I understand that there was an exchange of emails between Mr. Crane and Ms. Hobbs with the content of the conversation with the defendant.
Okay.
What's interesting is that the subpoena asks only for them to come and testify to the state. Does not ask for emails, does not ask for raw footage. However, when you ask what was the rest of this information, that's exactly what you're getting into. So they're trying to make it sound, Your Honor, like they're following Morris. But when they're asking for these additional details, then they are going into news-gathering information that was not published, that is protected, and at a minimum, your first question, which never got answered, have they exhausted other resources for that information? Because they are telling you a lot of things, and I have no idea if it's true or not. I mean, it's certainly not anything I'm privy to.
Okay. Well, I want to do a couple things just preliminarily to address a couple of the concerns you had, Ms. Counts. And that is, Ms. Hobbs can be in here. She shouldn't have been in here right now. But if she, it'd say she was in here now, but I appreciate that she's not here right now. If she was hoping to cover this matter, she can be here to cover the matter. It may well be in the end that she's going to need to come testify. We'll have to cross that bridge when we get to it. But to your point, I think that Mr. Crane goes first, and we see what happens as a result of Mr. Crane's testimony. But if there are allegations raised that there was no written anything approved of by Mr. McIver, then it may come to pass that Ms. Hobbs needs to come in here and talk about that. So it could be, and I'm relying on the parties to remind me, that Ms. Hobbs maybe shouldn't be in here where Mr. Crane's testifying. But for everything else, if she's someone who's interested in covering this, I'm saying she can be here.
And what specific statements are we talking about in terms of, for example, Black Lives Matter versus something else? Is that really material and crucial that this witness?
So, what I'm going to let you do is talk. I'm going to let you talk with the prosecutors about that. They owe you a more refined request based on what we've heard about here. It doesn't mean you'll agree to it when it's more refined, but I think it ought to be focused. But what I'm trying to make clear is that Ms. Hobbs is free to be in court to cover what she wants to cover. If and when we get to Mr. Crane, it might make sense for her to not be in court then, because he might be talking about his interactions with her. And so she should be out for that. But all the other stuff, if she wants to cover that. And same with Mr. Diggs. I don't know if he was planning on being in court, and Mr. Winnie, those interactions, would become germane only if they are called to testify. So I don't think there is a exclusion issue going forward, and if someone disagrees, they can bring it to my attention later. And if Mr. Snyder wants to fly down from New York and be here, he can do that. But I need to, I'm not going to rule on any of this right now, other than to say it's not an issue to have all these reporters in here, with maybe the exception of Ms. Hobbs when Mr. Crane testifies. But beyond that, they're free to cover it. And then I think actually the defense and the prosecution and I need to talk more about how the TV coverage would be admitted, if at all, so that I could get a better feel for what possibly Mr. Winnie or Mr. Diggs would be in the mix for. I just don't think it's crystallized enough for me to say that is within Morris or outside of Morris. In other words, it's not privileged or it is. And I appreciate all the policy considerations you mentioned, and those are discussed in Morris. It really boils down to, do we even get to the privileged area? And if we do, then we need to work through all that. If we're not, then I appreciate the policy things, but that's only when we get to the privileged side of things. Did you need more guidance from me to give to your people at this point? You're not being required to turn anything over right now. And the state has said they're not asking for anything, they're asking for someone at the appropriate time. And so we could then put a final gloss on it if we got to that point.
Thank you, Your Honor. And I would just say, and I'm not as familiar, I mean, obviously not as familiar with the facts as everybody else here, but it does seem like some of the things they're looking for, there are probably 8 to 10 other potential witnesses that would say the same thing.
Well, that's less clear to me when we get to Mr. Crane and what was explained. I don't know about...
Maybe if he's being charged for trying to change witness testimony?
Independent of the count, the nature of what he was purportedly authorized to share with the different media outlets is relevant to the way this case plays out. I found that already, and I continue to believe that.
Right.
So we'll have to revisit it. Right now, I don't think I can say it's definitely out or it's definitely in, meaning testimony from your clients or either set of clients. But I want to make sure I'm giving you enough guidance that you can report back to them saying, hey, you're good to go in terms of covering this. You're not going to need to take the stand until we have at least one more conversation, lawyers and judge.
And you will give us notice when we need to. That's what I'll tell them.
Okay.
Thank you, Your Honor.
Work for you too?
Yes,
All
absolutely.
right. Thanks. So, Mr. Rucker, before you run out, it's getting late, and I want you all to be prepared for tomorrow, which other than, I'm sorry, that's okay, other than openings, I don't know, implicates some of this 807, but I want to give you guys guidance. Are there any other witnesses that you think we ought to get through today, so you know what's in opening and what's not?
I will tell the court that during the opening, as part of the presentation, I was expecting to be able to say that the evidence in the case will show that Mrs. McIver was contemplating changing her will to make sure that her interest in the ranch would go back to her godson, Austin. And
so neither of the two witnesses so far, if they were both allowed to testify to what they shared with us today, get you that far. Mr. Brown gets you to changes in the will. We'll have to work through what Ms. Stiles gets you to, other than she copied something that Ms. McIver said was a will.
so my thought is to be able to call one more witness.
Okay.
And then and see whether or not that's established, and if the court feels like it can make a ruling such that we'd be allowed to present that in the opening.
Okay. What's the plan, gentlemen?
Well, Judge, after talking with Mr. Harvey, I think that there would be no objection from the defense if the state intends to call a witness, Ann Schwall, who there's no objection to her statement that Diane McIver told her that she intended to leave the ranch to Austin.
And that occurred in what time frame?
I believe that she will say it occurred a couple of years prior to her death.
Okay, so consistent with the time frame we heard about from Mr. Brown.
Correct.
Okay.
We'll check on the number of years. It may be a little bit more, it may be some 4 or 5 years ago.
But after 2006, I don't think Austin was alive in 2006. I don't know his age.
Right. That's right.
And I think that's not, I don't think we need another witness.
Okay.
For him to be able to say that generic statement, the evidence will show that.
Okay. All right.
And so in connection with that, I believe then that, perhaps we can take up the remainder of the presentation of any testimony from the witnesses, perhaps until a time at the court's convenience, but certainly.
My convenience will be your lunch break,
right
after we break for the day, right before we start. But I think it makes sense to stop soon so you all can be ready for tomorrow. I'm respectful of that need.
Right.
And I appreciate the conversation you and Mr. Harvey just had, because it sounds like the nugget you want for your opening in connection with 807 would be, and I need to rule, and I will in a moment, on Brown and Stiles, is you believe the evidence will show will was going to be changed, and part of that was that the ranch was going to Austin Schwall.
Right.
That a fair summary of what you want.
That's fair.
Okay. Anything more?
No. I think my early representation, and I appreciate the court giving us a minute to kind of work out some of these things. And so, in addition to that, the defense has no objection to, during Janie Calhoun's testimony, that she be allowed to state that Diane McIver told her that she was going to leave her the sum of $100,000 in her new will.
Okay. And what about the cutting Kathy Johansson out?
We don't have an agreement on that, and so
get half the statement. How does I got half the statement?
So I'm just telling you, I'm just trying, because everybody's been out here since 11 o'clock this morning.
Okay.
And so, for my purposes, I can live with that.
For now.
For now.
Okay. Got it. Mr. Samuel, I know you said you were done. I don't know who's going to be arguing it. If you want to have argument as to, and whoever's going to argue it, as to how I ought to handle what we heard from Ms. Stiles and Mr. Brown. Whether you want the examining attorney to argue it, or you're arguing it, or what.
I just think the question more is we argue it all now. We have other witnesses who are going to contradict what they say, and that's the whole point. I think it's premature to say, based on just what this witness said alone, I'm going to rule, when we're going to have another witness who's going to say, that's not what Diane's the truth of the matter certainly was. So it's inconsistency, so I'm not going to rule now. We got Ricker, who's going to say, there was no new will. I'm her lawyer, there was no new will.
I'm sorry, Your Honor, we heard argument from the defense earlier that we were supposed to consider these statements and the addition of reliability and isolation without regard to all this other stuff.
You weren't listening. It's done a two-way street. The state doesn't get to do it, but the defense does. That's specifically what the cases say. The defense is entitled to show indicia that the statement is untrue based on other circumstances. The prosecution, or really it's the proponent, because it could be us in other circumstances, the proponent is limited to showing the circumstances in which the statement is made. That's what Asensero says, Rivers says.
So that's a fair point. So what you're saying is you believe Mr. Rickard, Mr. Brown, I mean, it wasn't, I had a document and I only looked at the back or this or that. I mean, he said, I saw the front page.
Yeah, I was curious though. I don't know. I mean, maybe Ms. Carter can help me, but he didn't say this was the new will. He just said, here is a will, and I'm going to be making changes. Yes. Is this what's being changed, or is this the 2006 will from which I'm going to make changes? It was unclear to me, but I made.
No, I did. to me, it didn't matter whether it was a new one or the 2006 one, because he said she's making changes to it. That's what I latched on, coupled with it seemed to check a whole lot of the boxes of the 807 analysis, with the exception of if Mr. Rickert's going to come in here saying, no, I know for sure she wasn't contemplating changing things. Then you have that one-way street where two different witnesses would say something conflicting about what the declarant had to say.
That's all this one. I'm not going to argue the facts and the cause of
All right, I'll say this, and you can relay this to Mr. Rucker. I am comfortable, he should feel comfortable arguing what he wanted to argue. Arguing is the wrong word. Sharing in his opening what it was he wanted to share. And at another juncture, we can get some of these other witnesses on. Okay? So I need to read and maybe watch the statement to the two detectives. The tank team issue we're tabling for now. It sounded like you guys are going to talk more. But I understand better what the concerns are. I think it's too soon to sort out these media motions. Was there anything else you needed me to be working on so that we can move forward? You all have I appreciate the state sharing with the defense. Seriously, we're thinking about Colin, so you will have a better idea when we're getting closer to witnesses where we ought to talk first before that witness testifies. I'll rely on you to flag that. I would just like us to get going tomorrow. And I expect the state to have enough witnesses here each day that even if you have to take someone out of order, we don't reach 4 o'clock and the answer is, oh, you know what, we don't have any witnesses here. That would be a really bad development, unless you promise that as a consequence you'll lock 20 witnesses off your list. For every 5 minutes we end early, you'll drop a witness from your list. Okay. Any guidance you all need about how we'll work procedurally tomorrow, state?
At what time will we be able to come in and set up?
8:30?
Yes, sir.
Any guidance? I'll give a preliminary charge, reasonable doubt, it's okay to take notes, things like that.
You gonna tell them questions?
It'll probably come up. But if I forget, will you remind me?
About my continuing objection.
Yeah, you have a continuing objection on all your novel grounds as well.
We could have lots of questions. We just come up to the bench and just kind of cuddle up there.
We do. I give them to you to look at. And you're free to pour over them, and if there are enough, I might give half to the state and half to you, and then you swap. But we'll address each one. And if it becomes unwieldy, we'll need to come up with a different approach. One question is unwieldy.
Each question. 66 last case we tried. 66.
It was a jury interested in the truth. All right. Thank you, everyone. We'll see you in the morning. Let me know if you run into any logistical issues that I can help with.